Hello, everyone. Welcome in. With there having been 2 weeks since oral argument took place in Alexee Trevizo's case, and a lot of chatter, it being back in the headlines, a lot of legal analysts talking about it, even YouTube lawyers picking it back up again, I wanted to cut through all the noise and lay out the top 5 biggest problems for Alexee's defense at this point. These are the hurdles that could possibly unravel the entire strategy and all of the progress they have made thus far in suppressing many of these statements. This list counts down all the way from 5 to 1, which is the most important in my opinion. By the end of this, I believe you will see why I believe the evidence and law is really not on the defense's side. Starting off with number 5, the timeline is clear. The timeline of events, Alexee going to the bathroom, giving birth, hiding the baby, and then interacting with medical staff until the baby is found and police arrive is obviously devastating for the defense's case. In one justice, the one who I would say was least favorable to the state and most favorable to the defense based on his posturing at oral arguments, happened to be the one who skipped right over this period of time when asking a question. And that's very telling because he's not the only justice who skipped over this time frame. No other justices even asked questions about this time frame or clarified if the time from going to the bathroom until police show up would be privileged or not. And that is either really good for the defense, or what I think is more likely is it's extremely bad for the defense. It could indicate that the justices have subconsciously already realized or come to the conclusion, the logical conclusion, that Alexee wasn't seeking medical care from the time she went into the bathroom until the time police arrive. Clearly, since she was withholding pertinent information while the doctor was trying their best to figure out what was going on. And so no medical privilege should apply, at the very least, to the time of Alexee going into the bathroom until police come. And the fact that the quote-unquote most negative justice in his quote-unquote most negative question did happen to skip over that entire time frame could be very telling for us. Because why is no one wanting to address that part head on? Neither the justices nor the defense. It's very telling because you can't really claim privilege at a time when Alexee wasn't actually trying to get medical assistance. When it's not even an argument how it may be when she first showed up to the hospital before going to the bathroom. Now, adding the autopsy to the timeline, and that is clearly, in my opinion, going to be returned to the state as far as statements go, and that medical information from the time of going to the bathroom until police called will be admissible. That's an open and shut case. I've even seen one attorney on YouTube with a pretty big channel who I didn't agree with everything they said about this case, but that's okay. This is the law. Not everyone agrees. But he did happen to say that with what the state already has right now, with nothing coming back to them, they would be able to take this to trial and win. And that's essentially going to trial with the timeline we just discussed and the autopsy. And so it did not appear as though the justices had any favor for the timeline of Alexee going into the bathroom until the police show up, which could be dangerous for the defense. After all, we know what Alexee allegedly said when exiting the bathroom to explain the blood away, that she just had her period. That statement is a case ender. And just a reminder, the jury doesn't need anyone to testify to what Alexee may or may not have said in that time frame, because how baby Alex was found will say it for them. At number 4, we have the doctor no longer being seen as a police officer, because it's not even inherently necessary for a Miranda finding. And the basis for how it happened is a bit odd and doesn't seem to track. Essentially, the doctor did not invoke privilege on behalf of Alexee, so the district judge found that the doctor then became a state agent and Miranda was needed because of that. Rather than the typical Miranda situation of custody and interrogation coming from a police officer, this is where we get to Santiago. Just because the doctor aided in a police investigation does not mean that they are automatically considered a police officer. Santiago makes it clear that if there are mixed motives, then the actor cannot be considered a state agent in full, just like the doctor was potentially protecting their patient, complying with mandatory reporting laws, protecting the hospital, documenting for legal purposes. That would mean that even though the doctor complied with an investigation and relayed potentially non-privileged medical information regarding child abuse to the officers, it is not enough for the defense's argument to uphold. Also, to note, the doctor cannot legally hinder an investigation to which they believe is a child abuse or neglect investigation. Part of their mandatory reporting requirements also requires them to not hinder an investigation. Chief Justice put this to the defense and said this has a high burden for the doctor with how the defense was framing their arguments and how they wish it would have went. This question shows that the court does see problems with the defense's framing of the doctor magically becoming a police officer when aiding in an investigation that they're legally required to start and help with based on how they found the baby. So with that, let's get on to the next one. At number 3, we have the mandatory reporting problem. The defense took a big risk and a big swing with reframing the argument surrounding child abuse and neglect reporting and the waiver of privilege that comes along with that. Instead of having an argument and facing it head on, they chose to reframe and say that this should instead be a suspicious death report, not a report of child abuse or neglect. Obviously, because then the privilege would no longer be in jeopardy of being waived and statements would not be allowed to be entered. But the argument breaks down very quickly when you think about it rationally. It would put many children who could potentially still be in harm's way in a home where child abuse or neglect resulting in death could have occurred but could not be investigated. That is what would stem from the Supreme Court's ruling in favor of the defense on this particular issue based on their argument. They put a lot of emphasis on the statute saying if a child is a neglected or abused child, meaning that only live children can be reported as abused or neglected, an absolutely outlandish argument. And according to the rest of the statute, live children should be the primary focus of a child abuse or neglect investigation that happens once a report is made. But it is also for the welfare of other potential children who are in the home or the situation that the child who is alleged to be abused is associated with. How are police supposed to know Alexee didn't have other children who are in harm's way or who have been harmed? So you do have a duty to investigate the home of a potentially abused and resulting in death child to ensure that the home is safe for other children who are or may be there. And so it is a very risky argument to say that only live children can be reported for child abuse. It would be completely dismantling the reporting of child abuse by hospital staff and mandatory reporters if they have a critical child patient who passes in their care before a report of child abuse is made. How would that impact mandatory reporting? Because now that a child is passed, even if you could suspect abuse, you couldn't report it? It would have to be a regular or suspicious death report? Because again, the defense's argument would mean that only live children can be reported as abused or neglected. This would have such a broad negative impact. How could we really see the justices deciding in the favor of the defense, specifically on this point? Now, wouldn't it make it even better if we had a clip of the defense attorney potentially slipping up when trying to make this argument and putting it in the blunt truth, but having to stop herself before she finishes that sentence? Tell me if you realize the argument she's trying to make and the potential slip up that may have occurred before we move on to number 2.
The issue of what people knew at the time, as far as a report, there was no OMI report at that time.
It does triggering the suspicious death statute.
Correct. All they saw was a suspicious death. All they saw was a suspicious death. All they saw was a suspicious death.
Number 2 is what I would like to call the big oops. At oral argument, the defense attorney for Alexee Trevizo misstated a key fact that the defense attorney was apparently relying on to bolster the argument that we just talked about. A pivotal argument for the defense, because as we said, instead of choosing to address the waiver of child abuse or neglect report, they sidestepped in hopes to convince the justices that this should be a suspicious death report. So they better bring something good, and they failed. The defense seemed to be prepared with this claim that CYFD was never involved or contacted by the police based on this report, which would bolster their argument that this was a suspicious death report, not a child abuse claim. But what happens when you as the defense prepare an entire claim to support your weak, risky argument and state that something was nowhere in discovery, nowhere on the record, never happened, when it actually is on the record and did happen? You guys will see the clip here in just a second that now opens the door for the state to supplement the record and let the Supreme Court know that though this particular piece of body cam footage may not be on the record proper because it has not been necessary for the Supreme Court or this evidence at issue until the day of oral argument, but is in fact part of discovery in this case, they can now undermine this entire argument that the defense posed. So how can the defense's argument last? This was all they had. This was their one claim for the previous argument that we discussed, to switch this to a suspicious death report. This was it. This argument that they brought to bolster that CYFD was not involved. This is patently false, and you'll see that for yourself with these clips.
But there is also, for your honors, 24-11-5, and that's reporting a suspicious death. 32A43, is part of the Children's Code. And we know from Strouch and its legislative history that the purpose of that statute is to intervene and protect a child from ongoing abuse. And so hence the mandatory reporters that are reporting abuse. And that statute uses the language that a mandatory reporter, and obviously the doctor is one, if they have reasonable suspicion that a child is an abused or neglected child. And then it goes on to a whole slew of legislative rules that have to happen, including you have to report it either to police or to CYFD. If it goes to police, police need to report it to CYFD. CYFD then gets involved. That's not what's happening here. There's nothing in discovery. There's nothing in the record that police ever got CYFD involved because this isn't the operable statute.
Hospital. You've been talking to my supervisor.
Yes,
Okay.
Sergeant Chris. Yes. Will it be you guys tomorrow?
Yes.
Okay, I told him at 10 o'clock you could come over.
Okay.
Okay, you and your CYFD person.
Yes.
You and your CYFD person. You and your CYFD person.
That's not what's happening here. There's nothing in discovery. There's nothing in the record that police ever got CYFD involved because this isn't the operable statute.
You and your CYFD person.
This brings us to the best and final point, in my opinion. At one point, Justice Bacon does ask the defense, "You're essentially attempting to try and exclude statements that align with your defense." And the defense's response for that was that justice shouldn't be worried about that because that's trial strategy, and we're here to preserve Alexee's rights. It doesn't matter if it's Alexee's alibi, it's her rights that were violated. But inherently, in this question, I believe Justice Bacon firmly trapped the defense in one of their most glaringly inconsistent arguments that they have put forward since the beginning of this case, which is Miranda. Now, we've talked a lot about custody and interrogation as parts of Miranda, but right before oral argument, I said to you guys, the most important thing that could be realized is that Alexee's statements are not incriminating, which is the basis for Miranda. And Justice Bacon straight up asked the defense that question. Alexee's statements are the same statements, in theory, that the defense has continually argued. Stillbirth. That seemed to perturb Justice Bacon, as it should. It's the type of question that should strike some fear in the defense, in my opinion. Hear it for yourself.
Can I ask a really different question that's just been weighing on me? So assume the court agrees with you on either Miranda or privilege. Case goes to trial. You've indicated today that the basis of the defense will be stillbirth. Aren't her statements supportive of her own defense that you're working so hard to exclude here?
I see.
And so I see, like, you all will be gone. There will be a new attorney involved, probably a public defender, and we will have excluded statements that are consistent with what her defense is. And that just troubles me in a weird way. That's why I said it's just a related but far field question.
Now, this brings us to the other sneaky half of this point that I would like to share with you all. Not only are Alexee's statements and defense that she would like to use and issue in regard to Miranda, but if you guys remember, time and time again, not only on this channel, but then heard in oral arguments multiple times, we've talked about Rule 11504, which the exceptions to 11504 are listed under D. We have specifically at length discussed this entire case about D4, required reporting. Now, the other exception right above 4, obviously number 3, is elements of a claim or defense, which basically says that if a patient is relying on medical information as part of their defense, no privilege shall apply concerning the communications relevant to that defense. So, when the defense is over here cherry picking, in my opinion, these little medical tidbits here and there that no one told her she was pregnant, her placenta was never found, any and all of these medical statements that are trying to, again, in my opinion, be used by the defense in this case to blame the hospital rather than account for the suspicious and incriminating actions of Alexee, they hope that the privilege will still be waived despite all of that. But how on earth can they use the privilege as sword and shield, something I've been hinting and alluding to for quite some time without outright explaining this exception, because it's not been fully relevant yet, seeing as we've been focused on D4. But now that we're getting past that little hurdle, we have to move on to cutting off the defenses should privilege be upheld. Now, the second half of this D3 exception becomes extremely relevant and extremely timely in regard to the evidence in Alexee's case, because it continues on about after a patient's death. Should any party rely on the medical condition of that patient as a defense, then no privilege shall apply. Now, that would directly apply to baby Alex and his condition, which despite baby Alex never having been able to speak, the hospital staff may be able to speak on his behalf in talking about how they found him, the actions they chose to take afterwards, and the person who is opening the door to all of that being allowed in is the one trapped by the only defense they have by saying that baby Alex was a stillborn. Because inherently, the defense is the ones putting the patient's physical, mental, or emotional condition as part of a defense. So to counter that, the state will question those who saw baby Alex in the bag on the stand, revealing in their testimony just how he was found, because the defense will be the ones trying to highlight his stillborn status, therefore opening the door to the state's counter. This is devastating for Team Trevizo, and I just don't see how their case withstands the oral argument decision that will come from the justices. I don't see any world in which the justices don't give at least some evidence back to the state. And there's also the world where all of this evidence is returned to the state, and trial proceeds like a freight train at Team Trevizo. And if you thought I was done there, I did save one quick special explanation for you guys. Now, this is my opinion, but from how I see it, the defense has worked extremely hard to reframe the situation, reframe it in hopes that they keep this evidence suppressed. But as referenced in our number one most important point, when Justice Bacon points out that the statements trying to be suppressed are actually the same statements Alexee would be using in her defense, Justice Bacon also said something very revealing if you read between the lines. She said
that you're working so hard to exclude here, that you're working so hard to exclude here, that you're working so hard to exclude here.
Why would Justice Bacon think that the defense is working so hard if it's clear that their arguments make any sense at all? It reads as though the justice sees the hurdles that the defense is trying to jump. And if you'll remember, Justice Bacon also said that the attorney would be gone by the time trial comes. Why would Justice Bacon assume that this attorney wouldn't be there for trial? Well, here's my opinion. Because Justice Bacon sees right through this attorney. There are organizations out there, like Pregnancy Justice, who, in my opinion, are more focused on the ability to use cases to attempt to shape policy. Alexee's case would be very beneficial to anyone whose motive is to further expand pregnant women's rights. This isn't about Alexee's rights, in my opinion. This is about attempting to change mandatory reporting requirements specifically for the time after birth. I'm not saying that is the motive. I'm just saying these arguments could end up being non-beneficial to Alexee in the end. And I know those of you who know my feelings may be shocked to hear this. But I think these arguments are indeed unfair to Alexee when it comes to trial. If you've followed this channel, you've heard me say, my trial strategy wouldn't include Alexee's statements in the hospital bed. It matches her defense. It's the only time and way she can appear sympathetic. To see the hoops that have been jumped through to make the first suppression happen, and for oral arguments, and to see this pointed out from Justice Bacon, you begin to wonder, if Justice Bacon doesn't think this attorney will stay for trial, is that because Justice Bacon also thinks this attorney is arguing for policy rather than for Alexee? Justice for baby Alex. Thank you so much if you made it this far in this video. If you have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible. And I do genuinely enjoy the conversation. If you're interested in following cases like the Alexee Trevizo case to trial, please subscribe as I'll be covering it all along the way with a legal focus. It's your Friday. I'll see you in the next video. Goodbye.